Greetings, legal minds, and welcome once again to the lecture hall brought to you by MS Legal Market. Today, we will be examining some very important constitutional law principles and the rights of every individual in Nigeria as it pertains to arrest and detention, as embedded in the provisions of Section 35 and Section 36 of the Nigerian Constitution. And a proper understanding of these rights, if you obtain the knowledge of these rights, you will become a free citizen whenever an arrest or detention is being made. Because firstly, one of the things you must note as it pertains to the institution of criminal proceedings in Nigeria is that the arrest and detention is one of the things that kickstarts a criminal charge, that kickstarts a criminal proceeding in Nigeria. And because of the fact that the law, specifically the Nigerian constitutional law, respects due process so much, there are certain things that the law enforcement agents who are making this arrest and conducting this detention must appreciate, must comply with, so as to ensure that arrest, that detention is lawful. And when they abscond from these processes that have been provided for by the Nigerian Constitution, the individuals who have been arrested, who have been detained, would become entitled to some specific remedies provided for by the Nigerian Constitution. And for the purpose of this lecture series, I would briefly analyze some of these very important principles. The few principles we'll be discussing now would be based on what makes an arrest lawful and a detention lawful according to law. Yes, a close examination of certain laws and statutory provisions in Nigeria would make us understand that there are a variety of principles that makes for a lawful arrest, but I will be highlighting the very important ones. And this would be classified into the things that makes a lawful arrest before that arrest is made, the things that makes a lawful arrest during the course of the arrest, and the things that makes for a lawful detention during the course of the detention. Firstly, what is a lawful arrest? From the name, we can verily understand that a lawful arrest is simply a kind of arrest that is done by a law enforcement agent while following the due process of law. And you already know that generally for an arrest to be lawful, the first thing that must be done is that a warrant of arrest must be issued by the magistrate or the judge of a high court. This warrant of arrest is simply a document, it is an order made by that magistrate or the judge authorizing the law enforcement agent, who can either be the police, the member of the Economic and Financial Crimes Commission, and so many other law enforcement agents. The warrant is issued for the purpose of authorizing them to make an arrest. And with respect to our context, we can understand that there is a search warrant and the warrant of arrest. But the warrant of arrest is what makes an arrest by a law enforcement agent lawful. However, it is important to note, as expressly provided for in Section 4 of the Nigerian Police Act 2020, that there are some certain situations, there are some certain circumstances where the police officers are given the power and the ability to make an arrest without the issuance of the warrant of arrest. And these circumstances basically consist of the situations where they reasonably suspect that individual who is being arrested is committing or is going to commit a crime. So when it is seen that the police officer who made that arrest reasonably suspected the individual who was arrested to have committed a substantive offense, the law do not require the issuance of a warrant of arrest. From this now, we can see the very importance of the authorization of this law enforcement agent when making an arrest. And if the warrant of arrest is not issued and it is established that the police officer did not reasonably suspect that that individual is actually committing or has committed a criminal conduct, the arrest will become unlawful, thereby entitling that individual to some specific remedies, giving him the right to seek redress in a competent court for the enforcement of his fundamental rights. The issuance of a warrant of arrest is not what makes an arrest lawful, because a magistrate can actually issue a warrant of arrest, but during the course of the arrest, the police or the law enforcement agent failed to do some certain things that they've been obligated to do according to law. For example, according to the express provisions of the Nigerian Constitution in Chapter 4, law enforcement agents, when making an arrest or conducting a detention, are expected to inform that person who has been arrested of the reason for his arrest and a detention in a language that he or she understands. So therefore, Whether or not the magistrate actually issued the warrant is going to be immaterial when it is found that the police failed to comply with these specific provisions. And apart from that, the Administration of Criminal Justice Act 2015 provides that law enforcement agents, when making an arrest, should not handcuff the individual, should not subject that individual to unnecessary restraint. That means that when an arrest is being made, the Administration of Criminal Justice Act provides that that individual is not supposed to be handcuffed except in circumstances where it is seen that that handcuff is either supposed to protect the suspect or to prevent him from escape. It is also important to note that whenever a person is arrested, depending on the nature of the offense, he is entitled according to law to what is called a police or an administrative bail. This administrative bail is issued to grant him the opportunity to become a free man until the time for his arraignment. Except in serious and grievous offenses like treason, sedition, and so many other offenses against the state, every individual are supposed to be entitled to a free bail upon the production of a surety, given conditions for the issuance of that bail. Apart from this, something very important is also provided for in the Nigerian Constitution, specifically in section 36, which provides that everyone has the right to a legal representative. That means this is not just something that is provided in the Constitution, it is a matter of right. So when you are arrested or charged for the commission of a criminal offense, when you are arrested or charged for the commission of an offense, you are entitled, according to law, to a legal representative. You are simply entitled to a lawyer who is going to represent you in that particular case. And if you lack the capacity to appoint a counsel who is going to represent you, there is something known as the Legal Aid Council, provided for in section 46 of the Nigerian Constitution and section 1 of the Legal Aid Act, giving the state the obligation to provide lawyers that will represent you in that particular case. So these are the very fundamental principles you must note with respect to an arrest and detention in Nigeria. Take a look at section 35 and section 36 of the Nigerian Constitution so as to understand more of this. Thank you so much, and do follow the MSF and others to be updated when more insightful knowledge and legal tips